Members can then know, because this is going to be a long process, and members need not be here, I would hope, to listen to each of us do our statements. So members can know we're going to begin the 10-minute opening statements now.
Right.
Proceed. Some members could then estimate that they wouldn't be needed for a while. And am I correct that if we do get through all the opening statements tonight, that's all we will do, so that we will not be getting...
That is absolutely
so that
right.
once members have given their opening statements...
Markup will start tomorrow,
so
under any circumstance.
Members can calculate when they might be called on to give the opening statement and wouldn't necessarily have to stay around until the very last opening statement.
I would have...
Other than the chairman, of course.
Yes, the chairman is stuck. Has the benefit of hearing all of these opening statements.
Mr. Chairman?
At 10 minutes each, that's a 6-hour, with luck, process.
Mr. Chairman?
Just a minute, I'm hearing voices.
Over here.
Mr. Coble.
Mr. Chairman, I want to just extend Mr. Frank's comment. I assume that, well, strike that. Does the chair plan to take all opening statements tonight?
The chair is going to play it by ear. The chair figures 9-ish, 10-ish. Let's see how far along we are. I'd like to get the bulk of them over, so tomorrow morning, if we have any left over, we can dispose of them at 9 a.m., moving quickly along so that we can finish our work tomorrow.
Thank you, sir.
Mr. Chairman,
Yes, sir. Mr. Scott.
we had previously requested information from Mr. Starr. Do we anticipate getting that information before we have to start the markup?
We'll make inquiry. I don't know the answer to that, but we'll try to find an
Well,
answer.
we can speed it along with a subpoena if necessary.
I understand. Mr. Conyers and I would have to agree on that, though. You understand. All right.
What did he say?
If someone could check on it.
Yes, we'll take care of that.
All right. We're ready for opening statements, and Mr. Sensenbrenner is recognized.
Mr. Chairman,
10 minutes.
for the past 11 months, the toughest questions I've had to answer come from parents who want to know what to tell their kids about what President Clinton did. Every parent tries to teach their children to know the difference between right and wrong, to always tell the truth, and when they make mistakes, to take responsibility for them and to face the consequences of their actions. President Clinton's actions at every step since the media told us who Monica Lewinsky is have been completely opposite to the values parents hope to teach their children. No amount of government education programs and daycare facilities can reverse the damage done to our children's values by the leader of our country. But being a poor example isn't grounds for impeachment. Undermining the rule of law is. Frustrating the court's ability to administer justice turns private misconduct into an attack upon the ability of one of the three branches of our government to impartially administer justice. This is a direct attack on the rule of law in our country and a very public wrong that goes to the constitutional workings of our government. To me, making a false statement under oath to a criminal grand jury is an impeachable offense, period. This committee in the House decided that issue by a vote of 417 to nothing 9 years ago in the Judge Nixon impeachment. To accept the argument that presidential lying to a grand jury is somewhat different than judicial lying to a grand jury and thus not impeachable is wrong. It sets the standard for presidential truthfulness lower than for judicial truthfulness. The truth is the truth, and a lie is a lie, no matter who says it, and no amount of legal hair-splitting can obscure that fact. The evidence clearly shows that President Clinton lied to the grand jury, fully 7.5 months after the president's relationship with Ms. Lewinsky hit the front pages. Those lies were told because the president was unwilling to admit he repeatedly lied in the Paula Jones deposition in January. Whatever one thinks of her federal civil rights suit, the Supreme Court decided by a vote of 9-0 that she had the right to pursue it and to gather evidence to support her claims. Giving testimony under oath at depositions is one way parties to lawsuits are allowed to obtain evidence under our laws. The President lied numerous times at that deposition to obstruct Ms. Jones pursuing her right to get that evidence. When Americans come to Washington, they see the words equal justice under law carved on the facade of the Supreme Court building. Those words mean that the weak and the poor have an equal right to justice, as do the rich and the powerful. President Clinton's lies in that deposition were directly designed to defeat Ms. Jones' claims. He then lied to his cabinet and his staff so that they would unwittingly deceive the American public on this issue. And he appeared on TV denying sexual relations with, quote, that woman, Ms. Lewinsky, unquote. The president's defenders might claim that he did it to protect the First Lady and his daughter. While that might have been true right when the story broke, it wasn't shortly afterwards when all the personal embarrassment possible had already been caused. He didn't admit to an inappropriate relationship with Ms. Lewinsky until the DNA tests on that famous dress came back. And to this day, he still will not admit to lying at the deposition and to the grand jury, all to evade responsibility for his untruthful testimony. His repeated and continued failure to accept responsibility for his false testimony has brought us to the point where this committee is on the verge of approving articles of impeachment of a president for only the third time in our nation's history. Had President Clinton told the truth in January, admitted that he had made a mistake and suffered the consequences then, there would have been no independent counsel investigation on this matter, and we would not be debating impeachment here today. Mr. Clinton has recognized that his relationship with Ms. Lewinsky was wrong. I give him credit for that. But he has not owned up to the false testimony, the stonewalling, the obstructing the courts from finding the truth, and the use of taxpayer-paid White House resources to hide and perpetuate his lies. He has tried to use his apology for private misconduct to evade taking responsibility for the very grave public wrongs done to the judicial system's ability to find the truth. He has used legal hair-splitting and redefinition of words to perpetuate those lies and has continued to do so. The framers of the Constitution devised an elaborate system of checks and balances to ensure our liberties by making sure that no person, institution, or branch of government became so powerful that a tyranny could be established in the United States of America. Impeachment is one of the checks the framers gave to Congress to prevent the executive or judicial branches from becoming corrupt or tyrannical. Today, based upon the evidence that the President lied, obstructed, and abused power in an effort to prevent the courts from administering equal justice under law, I cast my vote in favor of impeaching William Jefferson Clinton. I do so with no joy, but without apologies, just as those on this committee who voted to impeach President Nixon 24 years ago did. Watergate and the Nixon impeachment reversed the results of an overwhelming election and were extremely divisive to our country. But America emerged from that national nightmare a much stronger country and will do so again after this sad part of our history is over. What is on trial here is the truth and the rule of law. Our failure to bring President Clinton to account for his lying under oath and preventing the courts from administering equal justice under law will cause a cancer to be present in our society for generations. I want those parents who asked me the questions to be able to tell their children that even if you are President of the United States, if you lie when sworn to tell the truth, the whole truth, and nothing but the truth, you will face the consequences of that action even when you don't accept the responsibility for them. I yield back the balance of my time.
I thank the gentleman. The distinguished ranking member from Michigan, Mr. Conyers.
Thank you very much. Mr. Chairman, my colleagues, and to the House itself, we stand poised on the edge of a constitutional cliff, staring into the void below, into which we have jumped only twice before in our history. Some encourage us to take this fateful leap, but I fear that we are about to inflict irreparable damage on our nation if we do. This inquiry began with the tawdry, salacious, unnecessarily sexually graphic referral delivered to us by an occasionally obsessive counsel in September with so much drama. And since that time, our proceedings in this committee have been marked by one partisan vote after another. Beginning with the majority decision to release literally every shred of paper received from Mr. Starr onto the internet. Although we have been able to reach accord on some matters, in too many respects this inquiry has been a textbook example of how not to run an impeachment inquiry. Time after time, we, the minority, have suffered the indignity of learning from the newspaper or television about important investigative or procedural decisions made by the majority. We learn about the decision to take depositions 5 minutes before the majority issues a press release to the world. One day, they decide to expand our investigation to campaign finance matters, and the next day read that the subject is off the table. Just yesterday, even while the White House counsel was concluding his testimony, the majority released its articles of impeachment, articles so vague that they would be dismissed by most courts in the country. So much for fairness, so much for bipartisanship. It's often said that power is best defined through its exercise. Well, all too often, the majority members of this committee have ruled this committee however they see fit. And I am sorry to say that we've fallen far short of carrying out our constitutional duties. The majority have simply rubber-stamped the uncross-examined, untested, double hearsay, yes, triple hearsay, and conclusions of the independent counsel without conducting any factual investigation of its own. Not one fact witness came before this committee. Faced with the failure of the process that they championed, the majority members this week adopted a new line of attack and tried to blame the president for not calling fact witnesses. My friends across the aisle, please let me remind you that it is you who are trying to overturn the results of 2 national elections. You who are attempting a legislative takeover of the executive branch, and you, not the president, who have the burden of coming forward with evidence to sustain your actions. On November 3rd, our citizens sent yet another message to all of us Stop the investigation. Stop the partisanship. Stop this impeachment inquiry. But the majority members of this committee have not heard the message, and now I want to address myself to those members in the House, not Democrats, who are undecided about what to do when this matter reaches the floor. And I want to talk to you about why I would hope and pray that they would vote against impeachment. There's no question the president tried to hide an extramarital relationship from the glare of his family and political opponents and lied to the American people in his January 21st press conference regarding this relationship. That was wrong, but it doesn't constitute perjury. And by the way, undermining the rule of law may or may not be impeachable. All lies are not perjury. Perjury may or may not be impeachable. If our hearings have made anything clear, it is that the distinction between personal misconduct and official misconduct has constitutional significance. Most Americans believe that their personal sex life is personal and should not serve as a basis for a wide-ranging criminal investigation of themselves or any citizen, and yes, not even the president. It should not serve as the foundation for overturning the will of the American people to a twice elected, popular, and successful president. The majority of our constitutional scholars have concluded that an offense is not impeachable unless it is political in nature. Our government functions under a principle of separation of powers. Under our constitutional system of government, if the president misbehaves in a way that does not impact on his official duties, the remedy still lies in the voting booth and not in a legislative takeover of the executive branch. And so to my Republican friends in this Congress, I beg you to consider the effect of a vote for impeachment on these facts. The Congress shut down the government before, and the results were disastrous for our citizens and for the majority party. A vote for impeachment is a vote for another government shutdown. That is because the matter would tie up the Senate, take the Chief Justice out of the Supreme Court, away from his duties, while he presided over the trial of the president, tie up the members of this body as they prosecuted the case in the Senate. Even worse, it would needlessly increase the division and polarization of our nation. Please, my friends, think about the subject matter of this trial that you're being asked to send to the Senate. This morning, we heard a detailed analysis from the minority counsel of why the majority's case against the president is factually unsupportable. Article 1 of the majority's articles of impeachment charges the president with lying in a grand jury, but the article fails to specify the particular statements on which the majority relies. This startling lack of particularity would be laughed at in a courtroom, or most courtrooms around the country. It's simply irresponsible to charge the president with offenses without having the courage to lay one's cards on the table and identify precisely which specific acts constitute the alleged offenses. And remember further, with respect to the alleged grand jury perjury, the president admitted to his improper relationships before the grand jury. Article 2 of the majority's articles charged the president lied during his deposition in the Paula Jones case, but as we saw with our own eyes, even skilled attorneys and a judge could not agree on what the definition of sexual relations in that case meant. The failure of the Jones attorneys to provide the president with a precise definition to ask follow-up questions when they knew from what Linda Tripp to ask shows a profound lack of candor on their part and reveals that deposition for the shell game that it really was, an entrapment. Surely the president cannot be held accountable in an article of impeachment for that. Article 3 of the proposed articles of impeachment charges obstruction of justice. But we know by now that the search for a job for Miss Lewinsky began long before she showed up on the Paula Jones witness list. We know.
The gentleman's time has expired. Could you close in a few minutes,
Yes, sir, I will.
Good.
We know that when the president spoke to Betty Curry, she was not expected to be a witness in any case and therefore could not have been tampered with. We know that the president didn't encourage Miss Lewinsky to file a false affidavit. I won't even quote her one more for the 100th time that she didn't ask anyone to lie or get promised a job for her silence. And finally, Article 4, and I thank you for your indulgence. The majority's article charges that the president abused his power by lying to aides and to the public and by asserting perfectly legal privileges in court. My friends, the president misled his aides and the country not to affect testimony, but because he didn't want anyone to know about his relationship. And really, how can the assertion of well-established privileges in a court case result in the impeachment of a president? It can't. It just can't. And I ask unanimous consent that the remainder of my statement be entered into the record. I thank the chair for his indulgence.
Without objection. The gentleman from Florida, Mr. McCullum.
Thank you very much, Mr. Chairman. The United States is the greatest free nation in the history of the world. The foundation of this greatness is our justice system. Instead of settling our disputes with guns and knives or paying off protection rackets as occurs in much of the rest of the world, any American who's injured may go to court and get a fair resolution of a dispute based on the law and the facts. A little boy who's run over while riding his bicycle may recover damages from the person who injured him. An elderly widow who has been bilked out of her savings by a fraudulent scam can go to court to recover her savings. A laborer may bring a workers' compensation claim when he's injured on the job. A person who's been discriminated against while seeking a job on account of race, religion, age, or disability may go to court for relief. A woman who's been sexually harassed by an employer or supervisor in the workplace may bring a civil rights suit for damages. And the list goes on. People who go to court in our system expect witnesses who are called to testify to tell the truth to the judge and the jurors. That's what we mean by the term rule of law. Without truthful testimony, justice can't be rendered and the system doesn't work. That's why a person who testifies in court is sworn to tell the truth, the whole truth, and nothing but the truth. And that's why if in court proceedings a person lies, encourages others to lie, hides evidence, or encourages others to hide evidence, he's subject to severe punishment. In fact, the federal sentencing guidelines state that people who are convicted of perjury or obstruction of justice are punished more harshly than those who commit the crime of bribery. And that's why if President Clinton committed the crimes of perjury, obstruction of justice, and witness tampering, he should be impeached. Under the Constitution, impeachable offenses are treason, bribery, and other high crimes and misdemeanors. If our courts for good reason punish perjury and obstruction of justice more severely than bribery, how could anyone conclude they're not impeachable offenses? Bribery and perjury both go to the same grave offense, the undermining of the administration of justice. And how could any person who fully understands and reflects on this fail to see that a president who gives perjurious, false, and misleading testimony in a civil rights action brought against him and before a federal grand jury, and encourages others to give perjurious, false, and misleading testimony, and uses the powers of his office to conceal the truth from the court and the grand jury and cover up his crimes, should be impeached. The president is the chief executive officer of the nation, the chief law enforcement officer of the nation, and our military's commander-in-chief. If we tolerate such serious crimes as perjury and obstruction of justice by the President of the United States and fail to impeach him, there will be grave, damaging consequences for our system of government. Studies show that perjury is an increasingly common occurrence in our courts. Contrary to what some have asserted, there are numerous recent examples of federal prosecutions of perjury in civil cases. There are at least 115 people in federal prison today for perjury in civil cases. If he has committed these crimes and is not impeached, a terrible message will go out across the country that will undermine the integrity of our court system. We will not only send the message that there is a double standard and that the President of the United States is above the law in these matters, but also a message that these crimes are not as serious as some people once thought they were. More people in the future will likely commit perjury in the courts than would be the case if the President were impeached. Furthermore, it will be far more difficult in the future for Congresses to impeach federal judges for perjury and the like, which we've done in the past. And there's bound to be repercussions in our military, where the commander-in-chief is treated quite differently from officers and other enlisted personnel who would be routinely removed from duty and discharged from the service for activities the President has admitted to, not to mention the crimes themselves, which no doubt would get a military officer court-martial. This is a grave matter we're about today. Unfortunately, I come to the end of these deliberations convinced that the compelling, clear, and convincing evidence before us demonstrate that the President has committed several offenses for which he should be impeached. In fact, I'm convinced from the evidence beyond a reasonable doubt that President Clinton committed a number of crimes that underlie the articles of impeachment today. His conduct constitutes a great insult to our constitutional system and subverts our system of government. Now, what about the evidence? The President was sued in a sexual harassment civil rights lawsuit by Paula Jones. He says the purpose of that suit was to politically attack him and embarrass him. That may be what he thought, but on its face, the suit alleged a claim of sexual harassment which Paula Jones had the right in our system of justice to try to prove in court. Part of her case was to try to bolster the credibility of her allegations by showing the President had engaged and was still engaging in a pattern of illicit relations with women in his employment. Whatever the merits of this approach, the court determined that she could proceed to try to prove it. Long before the President was called to give a deposition or Monica Lewinsky was named as a witness in the Jones case, the evidence shows that she and the President had an understanding they would lie about their relationship if asked by anybody. When her name appeared on the witness list, the President telephoned her and told her. During this discussion, he suggested she might file an affidavit to avoid being called in person. In that same conversation, they also reviewed the cover stories they'd concocted to conceal their relationship. In her grand jury testimony, Monica Lewinsky says the President didn't tell her to lie, but because of their previous understanding, she assumed that both expected her to lie in the affidavit. In this context, the evidence is compelling that the President committed the crime of obstruction of justice. A few days later, the President gave sworn testimony in the Jones case, in which he swore he could not recall being alone with Monica Lewinsky and that he had not had sexual relations with her. He repeated those assertions a few months later to the grand jury. The evidence shows he lied about both and about a number of other material matters. In doing so, the President committed the crime of perjury both in front of the grand jury and in his civil deposition. During his deposition in the Jones case, the President referred to Betty Curry several times and suggested she might have answers to some of the questions. When he finished the deposition, he telephoned Ms. Curry and asked her to come to his office the next day and talk with him. By any reasonable reading of the matter, one is compelled to conclude the President was at least in part concerned that Betty Curry would be called as a witness in the Jones case as a consequence of his own deposition testimony. Whether she was ever listed as a witness or actually testified is immaterial and irrelevant. Betty Curry told the grand jury that when she came in the next day, the President raised his deposition with her and said there were several things she may want to know. He then rattled off in succession. You were always there when she was there, right? We were never really alone. You could see and hear everything. Monica came on to me, I never touched her, right? She wanted to have sex with me, and I can't do that. It seems abundantly clear that the President was trying to influence how Betty Curry responded, not simply to press questions, but to the court in the Paula Jones case if she were called as a witness, which the President had every reason to believe could happen, and which he may have even wanted to happen, so as to corroborate his already untruthful testimony and to continue the cover-up. By encouraging her to lie to protect him in anticipation of her testifying in the Jones case, the president committed the crimes of obstructing justice and witness tampering, and the list could go on. But time doesn't allow me to discuss all of these. As Mr. Shippers testified today, the president engaged in a whole pattern of conduct over an extended period of time, which taken together demonstrate a scheme to conceal from the court in the Jones case the truth about his relationship with Monica Lewinsky, and later to conceal his previous lies, obstruction of justice, and witness tampering in that suit. It is not a case of one or two isolated instances that bring us to the articles of impeachment before us. If the entire fact pattern that has been unveiled to us in the thousands of pages of sworn testimony and documents we've examined were revealed to a criminal court jury, I'm convinced that they would convict the president of several felony crimes, including the crimes of perjury before the grand jury and in the civil case involving Paula Jones. And contrary to the assertions of some, it seems apparent to me that any prosecutor reviewing the totality of the evidence would bring the cases that we're talking about. We're dealing, however, with something graver, and that's the impeachment of the President of the United States. Some have suggested that we're ill-served by the time that would be consumed in the trial of these matters, but having examined the evidence thoroughly, I don't agree. Just the opposite is true. To fail to impeach the President, knowing what I know and believe would be the case, I think would be dereliction of duty on my part. There may be some particulars over the next day or two that I don't agree with that I find in the articles of impeachment, and I may vote to alter them, but sadly, I conclude that when all is said and done, I must vote to impeach President William Jefferson Clinton. To do otherwise would undermine the rule of law, undermine our constitutional system of government. Thank you, Mr. Chairman.
The gentleman's time has expired. The distinguished gentleman from Massachusetts, Mr. Frank.
After many years of investigations by every possible investigative tool of the federal government, congressional committees, the FBI under the command of the independent counsel, we have the following charge against Bill Clinton. He had a private consensual sexual affair and lied about it. Let's be very clear that that is what we are talking about. That seems to many people an insufficient basis for an impeachment. Indeed, among those who implicitly acknowledge that it's an insufficient basis for impeachment are all of those who have been trying so desperately to come up with something else. And I must say, after this committee subpoenaed and then unsubpoenaed all the people on the Kathleen Willey case, and subpoenaed and unsubpoenaed the people in the campaign finance case, I was disappointed to have Mr. Shippers begin today by an entirely inappropriate invocation of unnamed and unspecified further crimes, which he claims he is still investigating, and to waive them at this point in the proceeding as if they somehow justified acting when he is able to produce nothing to substantiate that is irresponsible prosecution. Mr. Shippers began by saying, oh, there's more out there. Well, why do people say there's more out there? Responsible people don't like to be in the position of making empty threats like that. It's not fair to anybody to say, particularly after 5 years and more of multiple investigations, oh, but there may be more out there. At some point, we have to come to a vote. Now, the people who said, well, we're in a hurry. The majority's been in control of this process. If you thought there was more out there, you could have waited. We have waited and waited and waited. And I think what we have is an implicit acknowledgement that impeaching the president because he admittedly lied to try to cover up a private consensual sexual affair is a mistake. Indeed, the previous speaker made a very important point I agree with. He said that the president and Monica Lewinsky, long before they knew about her potential role in the Paula Jones suit, agreed that they would try to cover this up. I agree. That goes contrary to the assertion that this was an effort to somehow frustrate justice in the Jones case. The president was understandably embarrassed. He had private sexual activity that he wanted to conceal, and he lied about it. And that is a subject, as an expert on which, I fully understand. The fact is that that's all we have. Now, we also have Mr. Shippers saying that, and I thought this was also very unusual, please do not be cajoled into considering each event in isolation and treating it separately. That's what people always do in conspiracy charge cases, he says. But of the 4 counts, only 1 could be described as a conspiracy count. 3 of the 4 deal only with sole acts of Bill Clinton. What Mr. Shippers is saying is, please believe that I have a whole that's greater than the sum of the parts, because they understand that the sum of the parts is not impeachable. The sum of the parts is, and the whole is, Bill Clinton gave in to a sexual affair that he shouldn't have had and lied about it. Now, that's it. Should that be impeachable? I feel strongly that it should not be. In the first place, the notion that this sort of lying always brings the harshest sanction is simply not true. And people have said, well, are you going to say that just because everybody does it, it's all right? No, that's never true. It is true, however, when people who have given one punishment in one case and then want to give a much harsher punishment in a very similar case, make that argument, it's legitimate to say they are motivated by something other than what they admit. We heard people suggest that if the president is not impeached, this will undermine morale in the military and lead to an outbreak of lying in the military. Well, I think our military is of sterner stuff than that. I think when George Bush pardoned the Secretary of Defense because he's been indicted for perjury, that the military shrugged it off. I don't think that had a negative effect. I think when we have had lying alleged in other cases by the president and others in national security cases, that didn't have a negative effect on the military. The fact is that previous cases of lying have called forth not only lesser condemnation, but congratulations from some of the members of this committee. And that leads me to believe that what we are talking about with impeachment is an effort to get rid of a president who has been inconvenient, not a consistent application of a principle. As far as the alleged offenses are concerned, I do believe the president lied when he said he wasn't alone with Monica Lewinsky. I also believe that when you are given a deposition in a civil case and are asked things that are not relevant, it is not in our interest to pursue that. Now, I will say to some of my friends on my side, we should be examining. I have been in the minority on my side from time to time in talking about curtailing the reach of private lawsuits. I think we do run into a problem where unlimited discovery in the case of unlimited right to bring lawsuits can lead to problems. I am not going to give the ultimate punishment to the President of the United States because he tried in a private lawsuit to which this issue was not relevant. And I believe that a purely consensual affair was in fact irrelevant to the Paula Jones case. I believe that this is not something that rises to that level. As far as the grand jury is concerned, and that I think is the heart of the argument, that he committed perjury in the grand jury. I know Mr. Shippers goes beyond Mr. Starr in his allegations of grand jury perjury, and I think that's unpersuasive that Mr. Starr was somehow being soft on the president. But he does it in part because the central charge that Mr. Shippers made, that Mr. Starr made for grand jury perjury is that the president, having acknowledged an inappropriate sexual affair, having acknowledged that there was sexual contact between Monica Lewinsky and himself, shortchanged us on the details. The president stands charged with being insufficiently graphic. He did not talk about what he did in reciprocation, and that is not a basis for impeachment. What it is, in my judgment, is a basis for censure, and I now want to talk about the difference between the two. I alluded to my own personal life before for a reason. I am struck by those who have argued that censure is somehow an irrelevancy, a triviality, something of no weight. History doesn't say that. There are 2 members of this House right now who continue to play a role, who were reprimanded for lying, myself and outgoing Speaker Gingrich. We both were found to have lied, not under oath, but in official proceedings, and were reprimanded. I would tell you that having been reprimanded by this House of Representatives, where I'm so proud to serve, was no triviality. It is something that when people write about me, they still write about. It is not something that's a matter of pride. I wish I could go back and undo it. I don't think Speaker Gingrich's political problems subsequent to his reprimand were unrelated to the fact that he was reprimanded. I am indeed surprised that members who share my reverence for this institution, my reverence for democracy, my deep, abiding faith in what Thomas Jefferson eloquently called a decent respect for the opinions of mankind, for all of us who are in this business of dealing with public opinion and courting it and trying to shape it and trying to make it into an instrument for the implementation of our values, to be dismissive of the fact that the United States House of Representatives or Senate might vote a condemnation as if that doesn't mean anything? Members know better. I cannot think of another context in which members would have argued that a censure, a solemn vote of condemnation, would not have meant very much. Certainly, former Senators Thomas Dodd or Joseph McCarthy would not have believed that for a minute. We have one last point. The Founding Fathers could have consigned impeachment to the court. They could have said, if there was an accusation of impeachment, the court would try it. They did, after all, recognize it as quasi-judicial by bringing the Chief Justice in. They didn't. They said it will be done by Congress. Those who say there should be no political element fly in the face of the Founding Fathers. They knew that if you asked 535 politicians to decide something, politics would be essentially there, and it ought to be. We are talking here about democracy, about whether or not an act of misbehavior was so grievous as to justify overturning the most solemn decision ever made by the American people, a presidential election. We're not debating whether or not this was right or wrong. It was wrong. But is it so wrong, so outrageous, that it must be overturned? I do not believe it is, and if I can have 30 seconds, Mr. Chairman, I would note a particular problem with that. Reality, from time to time, ought to be addressed. We have a very close vote coming. There are, by my count, 6 members of the House of Representatives on the Republican side and 1 on the Democratic side who were defeated in the November election, either for re-election or for another office, who were replaced by someone of the opposite party. For the most solemn democratic decision possible to be made by the American people, to be narrowly reversed by a margin less than the number of people who were defeated in the last election in which impeachment was an issue and were replaced by people who had the opposite opinion, is an absolute derogation of democracy. It is simply not sustainable that people who lost their right to represent the people in the last election to people who had a directly opposite view on this question ought to be the deciding votes. Censure is the appropriate response, and I hope the Republican leadership will not allow partisanship to keep the American people from seeing the decision they want and have a right to have made, censorship of this president.
The distinguished gentleman from Pennsylvania, Mr. Geekus.
Thank you, Mr. Chairman. Mr. Chairman, we've reached the moment of truth for our distinguished committee and for each member thereof. And speaking of the moment of truth, if the president had indulged in a moment of truth in that first deposition a long time ago in January of 1998, one small moment of truth, we would not be debating this momentous issue here today. But the president chose otherwise, throwing us into this morass of trouble and distinct tumult that we've engaged in for months now. So that moment of truth went by, was ignored, and now we're in trouble. I say that 1,000 historians and a swarm of political opinion polls and a gaggle of media programs and talk shows, none of those things can change the vital facts in this case, and that is that falsehoods were uttered in a court proceeding under oath, both in the depositions and later in a criminal federal grand jury. The Starr report, which was full of tapes and trips and conspiracies and machinations of people behind the scenes and theories of executive privilege and all of that, put it all together, package it all, and leaping out of that are the salient facts that the president uttered falsehoods under oath in the depositions and in grand jury, and later even to the 81 question circulated by the Committee on the Judiciary. Now, I myself, in reading and analyzing the materials of the independent counsel, came to a conclusion very early that I would not automatically adopt, as some people charge who are against impeachment, I did not automatically approve of and fall into lockstep with the allegations by independent counsel. In fact, I made it known early to my colleagues, to the media, and everyone else that I was taken aback by the averment, the allegation in the Star report on his allegation that the assertion by the president of executive privilege constitutes by itself or packaged with other matters as an abuse of power. I rejected that out of hand and then began to solidify my thinking on it till this moment when I announce again that when the time comes in these proceedings that we will be dealing with that part of the articles of impeachment, that I will renew my objection to inclusion of the assertion of executive privilege as an abuse of power. But still, leaping out of that mass of documents in those boxes in the Ford building and in all the testimony that we've had here is the recurring theme of perjury, falsehood under oath. We can't escape it. No matter what other allegations you bring in against Dave Schippers or against Abby Lowell or against any member of the committee, and especially against the independent counsel, perjury still resounds throughout the meeting of this in this chamber and throughout the congressional area of the Washington, D.C. capital of the United States. Wherever we go, perjury still rings out in all of these proceedings. When the witnesses continuously referred to it's not an impeachable offense because it is, as some of my colleagues have said, really based on sexual misconduct, lies about sex, that's so insignificant that we should not have bothered with it. Notwithstanding that other individuals, our fellow American citizens, are undergoing sentences imposed by the court for lying under oath about matters that you and I in our lives would consider trivial, yet they are undergoing sentences of the court. Perjury and falsehood under oath still leaps out at us. So when that moment of truth passed by, the ability to end everything by the moment of truth in the depositions which passed by, there was another chance for a moment of truth preceding the one we are engaged in now, and that was at grand jury. Again, that moment of truth could have saved us the embarrassment and the humility and the indignity of having to decide the fate of the President of the United States. And that moment where truth could have prevailed, again, was swept away by the motivations, however you want to ascribe them, of the President of the United States. When I engaged in a discussion with one of the witnesses on high crimes and misdemeanors and the comparison between bribery and perjury, I was struck by the fact that they maintain, and I think it's absolutely correct, that if one finds bribery as an offense committed by the President of the United States, a 10-minute transaction in which either he as a bribee or as a bribor passes money or receives money for something not having anything to do with national security or not having anything to do with the conduct of his office, but an exchange of money, bribery, 10 minutes in his duration, could constitute grounds for impeachment. Does anyone disagree with that? But perjury, which is viewed by scholars and these same historians who enter our premises and spout the holiness of their positions, would agree that perjury, even in our statutory law and our common law perceptions and in practical application of the statutes, is more serious than bribery. And when coupled with the reality that every act of perjury strikes at the heart of the judicial system, endangers our individual rights to receive justice at the hands of our fellow citizens in the court system, then you can see that bribery, that quickly passing offense of not having to do with the national weal, all of a sudden, in the face of perjury, we cannot face the reality that that perjury, falsehood under oath, has the capacity to destroy a branch of government, two branches of government. As a matter of fact, all three branches of government. If it's uttered by the President of the United States, he is diminishing the presidency, the executive branch. If he does so in a court of law, he is trampling against the walls of security that the court system provides all of us. And he injures the legislative branch because he forces upon us the indignity, I say, of having to deal with misconduct of the president that might lead to impeachment.
How long is it?
When all is said and done, the moment of truth will recur. And it will recur as each one of us finally indicates to the chair and to the clerk the final vote in this issue. I cannot erase from my mind or from the atmosphere of the capital of the United States or from the entire land, from the entire globe, the falsehoods uttered under oath. I yield back the balance of my time.
Thank the gentleman, the distinguished senator-elect from New York, Mr. Schumer.
Thank you, Mr. Chairman. When the Founding Fathers designed the government of this country, they realized that there would be rare and crucial times in history when it would be necessary to break into the regular order of how our government works, to pull the nation out of crisis and, in fact, save the republic. They devised the process of impeachment for these times, to be used rarely and only in times of national crisis. Several weeks ago, the notion that we would be on the verge of actually using the hammer of impeachment to remove the president for just the third time in 200 years was unthinkable. Now we're only one day from possibly passing a resolution to remove a duly elected president from office. And the actions that we take tomorrow far transcend the conduct of Bill Clinton and will have profound consequences on the future of this country. If we vote articles of impeachment, I fear that we will be setting a precedent that could seriously weaken the office of the presidency, whether the president is removed from office or not. In my judgment, we will be substantially lowering the bar for removing a sitting president so that we will be in danger of all too frequently investigating presidents and seeking to remove them from office. This as we enter a century which demands a strong and focused president of the United States. And what would we be removing him for? Sex and lying about sex. Today we have 4 charges before us against the president: 2 perjury counts, obstruction of justice, and abuse of power. I would venture to say that if the obstruction and abuse charges were brought before an impartial jury of randomly selected American citizens and tried by competent lawyers on both sides, the president would be acquitted by a 12-0 margin. Neither case is supported by the evidence. Regarding obstruction of justice, the level of exculpatory evidence exonerating the president concerning the job search, the gifts, and the president's conversations with Ms. Curry is overwhelming and convincing. And the abuse of power charge does not pass the laugh test. Indeed, the charge itself is at least as much an abuse of prosecutorial power as the actions of the president in this count. In perhaps the most Kafkaesque of all the charges is that when the president misled his staff under no oath whatsoever by denying an extramarital affair, he was committing a crime. So this case, this impeachment, boils down to 2 perjury charges. I agree that the president's testimony was misleading, maddening, evasive, prevaricating, and designed to shed as little light as possible on his embarrassing personal behavior. I've said so since September, that the president lied in his testimony and to the American people, but that he did so about a sexual relationship, not about matters of governance. The Republicans want the American people, or most Republicans want the American people, to equate lying under oath about sex with lying under oath about matters of state. In their wisdom, most Americans can easily see the distinction. The American people know that being evasive about an extramarital relationship is worlds apart from being evasive about matters that go to the core of running this republic. That is why there is such a huge gap between what the majority on this committee want and what the majority of Americans want. Yesterday, former prosecutor Sullivan stated the average citizen would not be tried and would not be punished for committing such acts as the president's is accused of. However, the president's not an ordinary citizen. He has to be held to a higher standard. He should be sanctioned, not as a political denouement, but because we cannot let posterity believe that a president who so misleads under oath can be allowed to avoid punishment. So the question before us is not whether to punish the president. The question is the magnitude of the punishment. The question is what punishment fits his actions. I agree with the majority of Americans that impeachment would be wrong. A strong censure motion, such as the motion before this committee, signed and acknowledged by the president, is the appropriate punishment. It would be a miscarriage of justice to impeach the president over a private affair or about lying about that affair. And that is not simply my subjective view. That is what the Founding Fathers intended when they put the impeachment clause in the Constitution. That is what they intended by spelling out the terms of bribery, treason, and other high crimes and misdemeanors in Article 2, Section 4 of the Constitution. In September, when I first saw the president's testimony on tape, it angered me. When I saw it today, it angered me again. While the president may not have committed perjury, he misled in such an artful way that I could see why people, liberals and conservatives, Democrats, independents, and Republicans, men and women, would be angered and disappointed in the president. But I was also angered and disappointed by the Ken Starr referral. It was unbalanced. It was full of prosecutorial and partisan zeal. It was intentionally salacious. It lacked the seriousness and gravitas of a document that would guide this Congress on the crucial question of impeaching the president. It raised obvious questions about Ken Starr's partiality and veracity. I believe that because Starr knew that a case solely about sex and lying about sex would never pass muster with the American people, that he leveled the unsupportable charges of obstruction of justice and abuse of power. And many House Republicans, because of their hatred of President Clinton, were only too eager to accept the OIC's case without question. The 4 articles before us, with rare exceptions, seem like a rubber stamp of the Starr report. And this is a very sad indictment of what should be a very solemn and judicious process. And it leads us to today. The American people may wake up Sunday morning to find out that this committee has passed articles of impeachment on the president. The American people may wake up next Friday morning to discover that the House of Representatives has indeed impeached the president. You know, I think the American people still don't believe that we're foolish enough or partisan enough to do this. I think the American people are waiting for us to come to our senses and end this political game of chicken. But to the American people, I say that the House may very well do the unthinkable. If the vote were held today, I believe the House would impeach the president by a thin margin. I don't think many from the other party are willing to buck the siren calls of the radical right. I read one columnist who said that impeachment won't really tie things up not for too long. The Senate will never convict and it'll be over in a few weeks. Well, let's not delude ourselves. If the House impeaches, we will tie up all 3 branches of government for months and months. The House Judiciary Republicans will prosecute the case with all of the zeal that we have seen thus far. The president will call witness after witness because he can and because to defend himself he must. The Supreme Court Chief Justice will hear the case in the Senate. The Senate will be paralyzed from legislating. And it will poison relations between the House and the Senate, between the Congress and the White House, between Democrats and Republicans for a long time after the trial is over. And all the while, the crushing problems around us in Iraq, in the Middle East, with the world economy, with health care, with education, with Social Security, will fester. Clearly, if the president's actions were so egregiously wrong that they went to the heart of the continuance of the Republic, we would have no choice but to move forward, even with the risk of all these problems being ignored. But now the majority wish us to go through this ordeal simply about an extramarital relationship and lying about it. To the members of this committee, to the members of this House, before we act, remember, this is not simply about President Clinton. It's not about the opportunity of the moment to tarnish a president who has frustrated you and maddened you. It's about the careful balance designed by the Founding Fathers that has served our country well for over 200 years. Don't upset it without the most careful deliberation and the strongest of reasons. We may never be able to put the genie back in the bottle. God willing, please let history, justice, wisdom,